Yeah. Good evening. Welcome to the April 17th, 2013 Planning and Zoning Commission meeting. At this time, I'd like to ask you to take your cell phones and put them on mute or turn them off if you haven't already. Thank you. All right, if you would stand and face the flag and repeat with me after me. I pledge
allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Again, welcome. Applications heard during tonight's meeting will be voted on by the Planning and Zoning Commission during the meeting tonight. The Planning and Zoning Commission's recommendation on these applications will then be submitted to the St. Charles County Council for their final decision on the items. The individual items or bills will be introduced at the Monday, May 13th, 2013 County Council meeting. I see we have a quorum this evening. Will someone move that we open?
I'll make a motion.
It's been moved. Is there a second?
Second.
All in favor, sign aye.
Aye.
Any opposed? Good. The following documents are introduced as a matter of record for the public hearing and regular meeting of the Planning and Zoning Commission. The Unified Development Ordinance of St. Charles County, including zoning maps, and the year 2020 Master Plan for St. Charles County, which includes the year 2020 Future Land Use Plan map. And just to give you a little roadmap for the evening, we will read the application into the record, and then we will ask the Planning Division for their analysis and recommendation. We will ask any questions of staff that we have. Then we will ask the applicant if they wish to come up and they can explain their application and answer any questions that we may have for them. We will then open each application up to the public, and anybody in the room that wishes to speak on that matter may do so. And as a reminder too, be sure to fill out a speaker card so we can have a record of your notes. Then after the public hearing is over, we will discuss the matter openly and then make our recommendations. All right. The first application this evening is 1768H, which was placed on the table at our last meeting, so I do need a motion to bring this up from the table.
I'll make a motion. So move.
Is there a second?
Second.
All right. All in favor, sign aye.
Aye.
All right. Application 17688, the preliminary plat for Willenbrink Farm, Plat 2 by Boucher and Ditch and Associates, Inc. Applicant Margaret Willenbrink, Living Trust owner. The property, known as 101 Willenbrink Drive, is zoned A, Agricultural District, 5-acre minimum lot size, and is located on the northeast corner of Osage River Road and Willenbrink Drive within County Council District 2. Staff?
They have, the plat meets all of our requirements, except for they have requested a variance to not have a temporary turnaround. They have a stub street as part of their development, and they've requested not to have a temporary turnaround at that location. This plat serves one lot. We did receive letters from Soil and Water Conservation District and their variance request. And, yeah, Gary?
Yeah.
I had a question. I was reading the soil analysis. Map unit 60001. The soil does not meet hydric criteria. The next one down, 6003, the soil does not meet hydric criteria. And areas of concern, not only the cleaning, silt control, dwelling, septic tanks, and vegetation. How is that going to be addressed with the soil, which came from I guess Steve Lauer got a letter from St. Charles Soil and Water Conservation District, but pretty detailed. And I know it's a rural area, but I'm just curious.
And the Soil and Water Conservation District, they check all of the plats for us and give us the soils analysis. And then that information is used by, like in this case, the building division for when we're doing the testing for septic tanks and things, or if things need to be done for the foundation on the house, so that there won't be problems with it. A soils report like that doesn't necessarily mean that the site can't be developed. It just means that there may be other engineering that needs to be done in order to make everything work. And the building division.
Yeah, we've had these in the past, but the letter that Don Johnson had written to Mr. Lauer, we encourage you to require compliance with all our recommendations. Normally, it's something not as, I guess, detailed as this. So I guess this is part, these recommendations on here, would that be part included on page 2? Would that be included in approval of this? There's areas of concern, number 1, number 2, number 3, number 4, and then recommendations. Would those be included to have this thing, this application come up to
Yeah,
standards?
we no longer make the plat subject to this, to these conditions. Through staff review, we work out everything with those conditions. Sometimes their conditions are things that aren't necessarily county requirements. And I mean, and I'm not saying that in this case. All of these things will be looked at as we move forward for the building permit and things of that nature, and putting in the road bed, things like that. But how do I say this? There had been a decision from above us in planning and zoning that we were no longer going to make approval of plats conditioned on soil and water conservation items. And so the staff takes further review of that.
Thank you.
Any other questions for staff? All right. Is the applicant here? Would they care to step forward? Please raise your right hand for us. Do you swear to tell the truth, the whole truth, so help you God? All right, thank you. State your name and address for the record.
Okay. My name is Mark Ditch. I live at 6165 Highway 94 South, Augusta, Missouri, and I'm here to represent the owner and developer of the subdivision. Can I take this?
Yeah.
You're up.
Just kind of a little history about this is this was part of an earlier, about, I don't know, 5 or 8 years ago, we came in and this was one lot of a subdivision that we had proposed, got approval, and then the time expired, we didn't get the plat recorded due to the economy and things. The other lot was going to be sold. This lot is going to be maintained by the original owner of the property, the Willenbrink Estate. And they since, right before we filed the plat, they had sold the rest of their property to Jerry Stachensky, and Jerry's here tonight. So this remaining 5 acres we need to subdivide to get, I guess, to make it legal for the remaining heir of the Willenbrinks. It's a one-lot subdivision. It is Plat 2. Just right across the Willenbrink Drive is Plat 1, and that was a lot that's currently owned by one of the Willenbrink daughters. Excuse me. I guess I need to address the variance request, and I'll do it at this time. The developers would like to not build the cul-de-sac, and after looking at it, the road length is about 380 feet long. If somebody comes in and they have to turn around, there's a driveway about halfway through, on the road that they could back up in and turn around. As far as emergency vehicles, the fire department out there, it's all volunteer firemen, and they all live in the area. And it's a pretty tight community. In fact, one of the Jim Willenbrink, who will be getting this lot, is on the fire department. So, we'd like to request consideration for that variance. And I'd be happy to answer any questions that you might have.
Any questions for the applicant? No?
No?
Thank
Okay.
you.
Okay, thank you.
We will now open this up to the public, so if there's anybody in the room that wishes to speak on this, feel free to come forward. Come on. All right, go ahead and raise your right hand for us. Do you swear to tell the truth, the whole truth, so help you God?
I do.
Okay, state your name and address for a record, please.
My name is Gerald Stachinsky, and my home address is 298 Sanders Road. And I speak about the address of the property, which is 340 Osage Ridge Road. And I purchased the acreage, the farm, and I also own the road. And I'm speaking for the variance, that we do not have to have a turnaround down there. I just really don't think it's necessary. That's the only statement I have to make.
Any questions? All right, thank you.
Thank you.
Is there anybody else in the room that wishes to speak on this? All right, we will close the public portion of the hearing and bring it before the committee. Any discussion, questions, comments? All right. I have, as far as the variance goes, will we need to vote on that separately, or do we include that or as far as the variance goes?
Yeah, vote on it all at once.
Okay. All right. Is there a motion to approve this application? So moved. Is that with the variance, or?
I guess both together.
Yeah, as long as you state the motion to approve the application along with the reduction.
Along with the, okay, yeah.
My second.
All right. Mrs. Keckner, how do you vote?
Yes.
Mr. Kuhn?
Yes.
Mr. Leonard?
Yes.
Ms. Polly?
Yes.
Mr. Settley?
Yes.
Mr. Cronin?
Yes.
I vote yes. Mr. Ellis?
Yes.
Mr. Fromm?
Yes.
Mr. Griffin?
Yes.
All right. The motion carries 10-0. The next application is application 17983 by Lloyd G. Fears, Senior, owner applicant. The application requests a rezoning change from A Agricultural District, 5-acre minimum lot size, to R1A Single Family Residential District, 1-acre minimum lot size. The property, known as 5704 Lake St. Louis Boulevard, is located 1,000 feet east of Lake St. Louis Boulevard and 950 feet north of Hawk Ridge Trail. The property consists of 2.4 acres and is located within Council District 2. Staff?
Thank you. Land uses in the area to the north, south, and east are vacant, and the zoning to the north is in the city of Lake St. Louis, and its commercial zoning district. To the south is R1A, single-family residential. To the east is in the city of Lake St. Louis, and its highway commercial district. To the west is a vacant nursery and a single-family residence, and that's zone C1, neighborhood commercial, and A, agricultural. In reviewing the application, staff finds that we did rezone the adjacent property, I think it was late last year, to the R1A. What happened when they put in the commercial commissary and split the property, they needed to rezone down to the R1A. They had residences on the site, but the dividing of the lots caused the need for the R1A zoning. Relative to the 2020 master plan, the area is slated as a mixed-use area, and we envision this to all be part of a large-scale PUD, and we're working on the new master plan, and we're probably recommending this area even be more of a office complex. So rezoning the existing single-family residence to R1A isn't going to hamper that future development of the site through the master plan. So staff is recommending approval.
Any questions of staff? All right. Does the applicant care to step forward?
Hi, guys.
Hi. Welcome back. No fireworks this time. No fireworks this time. Can you raise your right hand for us? Do you swear to tell the truth, the whole truth, so help you God?
I do.
All right. Can you state your name and
Yes,
address for our
Sandra
record?
Fears. My address is 21585 Highway 54, Louisiana, Missouri. I'm here tonight for my dad. And as you can see, we have a chopped up mess there. So, because of Jan, it's not her fault, but when we came and had the other part changed last year, that's when she told us on the other one that if something happened to the house, to get a building permit to fix it, we wouldn't be able to. So now we've applied for the zoning just to get it all in line and everything going the right way. So that's the purpose of it, is to get it to where we need it to have. Okay. Any questions?
Any questions?
Yes, sir.
So you don't have plans for putting 2 homes on this?
No, not at all.
And if they decide, if the zoning request is passed, okay, would they require an additional hearing to put 2 homes on that site in the future?
Well, they would have to, in order to add additional homes, they would have to have public water and sewer to the site.
Okay.
And they would, I'm pretty sure they would have to plat a subdivision. Yeah, they would have to plat a subdivision
I guarantee
plat.
you that it's not going to happen unless the developer buys it.
Yeah, because they have met their maximum number of splits that they can do without platting it as a subdivision plat. So that would necessitate it coming before you.
My concern was we have a house, 2 houses on 2.4 acres with septic tanks, but that's not a concern.
No, that's
Correct.
part of it, that it has to have public water and sewer coming
That's,
into it.
that's fine. Thank you.
Okay,
Thank you.
thank you.
We will now open this up to the public. If there's anybody else in the room that wishes to speak on this, feel free to come forward. Seeing none, we will close the public hearing and bring it before the commission. Any comments and discussion? All right, is there a motion to approve?
So moved.
Second?
All right. Mr. Griffin, how do you vote?
Yes.
Mrs. Keckner?
Yes.
Mr. Kuhn?
Yes.
Mr. Leonard?
Yes.
Ms. Polly?
Yes.
Mr. Settley?
Yes.
Mr. Cronin?
Yes.
I vote yes. Mr. Ellis?
Yes.
Mr. Fromm?
Yes.
All right. Application is approved, 10-0. All right. The final application for the evening is conditional use permit number 18148 by John O. J. Kajar, applicant representative, JOK's LLC, and 2 Branch Marina owners. The application request is conditional use permit for a campground. The property is zoned A/FW Agricultural District with Floodway Overlay District. The property, known as 1991 and 2021 Highway C, is located on the west side of Highway C, approximately 4,000 feet north of Highway B. The property consists of 19.23 acres and is located within Council District 6. Staff?
Thank you. Okay, zoning's in the area to the north is C2 FW General Commercial District with floodway overlay. To the south is A FW Agricultural with floodway overlay. To the east and west are also zoned A Agricultural with floodway overlay. Uses in the area to the north is a marina, to the south is agricultural, to the east is single-family residential, agricultural, and a campground, and to the west is a marina. In reviewing the application, staff looks at the site relative to the health, safety, and welfare of the citizens of the county. We find that the use of the property for RV campsites is appropriate. With recreational uses are a good use for in the floodway. That way we don't have permanent development in the area. The RVs are required to be highway ready so that they can be quickly disconnected and leave the property. Each RV has to be equipped with its own self-contained waste disposal system, and then the building division will work with the applicant on the size of a holding tank that's going to be required and how often that's going to be emptied. Thank you. Sorry. My mind gets ahead of me. They are proposing 24 RV lots at this time. This is different from the last application. They have added another property to it and have changed the number of RV sites from the 14 that was the final number that went through council. Staff is recommending approval, subject to the following conditions. A site plan must be submitted to and approved by the St. Charles County Community Development Department, which is in conformity with the site plan submitted with the conditional use permit application. Only RV camping will be permitted. The county shall have the power to enter at reasonable times for the purpose of inspecting and investigating conditions relating to the enforcement of this conditional use permit. The maximum number of RV sites is limited to 24. 6-inch gravel road access shall serve the RV sites and be at least 24 feet wide. RVs may be on site for no more than 180 days during the calendar year and may not be leased for transient use. Each RV site shall be marked with a site number in a manner that is identifiable to emergency providers. All RVs must have self-contained waste storage compartments. Any other proposed method of sewage disposal shall have the approval of the Director of Building Code Enforcement prior to the commencement of any construction and shall comply with all appropriate state laws and local regulations. The RV park operator must provide an RV disposal station and shall have the approval of the Director of Building Code Enforcement. Waste hauling tickets/receipts shall be made available to the county for inspection upon request. Solid waste disposal shall be provided. All garbage and refuse shall be stored in a durable, watertight, rodent-proof, fly-proof container with tight-fitting covers. All containers shall be maintained in a good state of repair and shall be kept clean. Collection and disposal of garbage and refuse shall be in an approved manner and of such frequency as to prevent a nuisance or health hazard to campers or adjacent areas. An adequate number of containers shall be provided for the depositing of garbage and refuse. Containers for garbage and refuse shall be supported in such a manner as to minimize tipping or spillage, and the area around such containers shall be kept clean. 8, a pressurized water system adequate to serve all anticipated needs shall be provided. Water supplies shall meet all current requirements of the department. They shall be properly located, constructed, and protected to exclude surface contamination and to minimize the potential of contamination from sanitary hazards. All portions of the water system located in the RV site shall be easily accessible for maintenance. The ownership of all portions of the water system serving the RV site shall be made a matter of record to the department. 9, the RV site and the premises shall be maintained in a clean and orderly manner. Additional vehicles stored at each RV site shall not exceed 2 trailers for recreational equipment, and such trailers shall be road-ready and capable of being loaded on a road-ready trailer or other vehicle. 11, no more than 1 RV may occupy any RV site. 12, each RV shall be designed to provide 1 parking space for the occupant of the RV. 13, the person to whom a permit for an RV park is issued shall at all times operate the RV site in compliance with this regulation and shall provide adequate supervision to maintain the RV site, its facilities, and equipment in good repair and in a clean and sanitary condition at all times. 14, a 6-foot-tall privacy fence or dense landscape buffer shall be provided along any property line where the adjacent land use is a single-family residence and where the campground lot is, or where a campground lot is less than 100 feet from the property line. 15, no conditional use shall be in active use until such time as all conditions of approval have been met. 16, in any case where conditional use is not in place and in active use within 2 years from the date of granting and/or in accordance with the terms of the conditional use originally granted or subsequently amended, then without further action by the Planning and Zoning Commission and/or the County Council, the conditional use or authorization thereof shall be null and void.
Can you repeat those for us?
See why I normally write 3 conditions? Yeah. Okay, we do have letters. We have a letter from MoDOT, from John O.J. Kajar, from Lawrence Lekren in support, petition of support with 24 signatures, petition of support with 31 signatures, a proposal from O'Fallon Sewer Service, an evacuation plan, and then a letter of opposition from Hazelwood and Weber. Any questions of staff?
I've got a couple.
Yes, sir.
I was reading those. One of them you probably asked. I was reading from the county council meetings of November 13th, and Councilman Doherty had mentioned at the time you were imposing 14 RVs on the site, and now you said that they bought some other land. How much land increased it so they would get to the 24?
They own, this is an additional piece of property, so they are adding extra on there. I'm sorry, I don't have the math.
All this, and also from the council members, besides, one of the limits with the 14 was also concerned with traffic, and now that they have a larger land, we're going to 24, so you're going to have more traffic, I guess.
We have, as staff, don't find traffic to be a problem.
Then I have another one for Mr. Hoynek, because I guess reading the letter, which we're going to hear from one of the attorneys, what is your interpretation of resubmitting an application for the governing body with 12 months from the date that it was turned down? This is in second page of Hazelwood and Weber's. Are we out of bounds with that? Or if I read that, if we're violating that, I don't see we would even be hearing this.
Well, they can resubmit, excuse me, in cases where the use requested in the new application differs from that presented in the original application. So that becomes a matter of interpretation. What's the use?
Yeah.
How does it differ? Here it sounds like you've got a difference in, it's still an RV campground. The use is in more lots. And then is it, does it differ? They're tending to use, it sounds like a percentage increase here, which if you find that it differs, basically 83% more is a difference. Is that substantial? And the real question is, would a decision, if a court would look, if a court would look at this, it would be, is a decision arbitrary, given this language and the increase from the previous application, is that reasonable to say that this differs? I can't, those are what the standards would be.
I've been here 3 times. The first time there was some non-compliance issues, and then it came back in a little bit different form with an ownership, basically the same people, kind of a substance over farm thing, and that was brought back, and that was denied. So now it seems like this thing just spins around with like, hey, it's brand new, and that's kind of hard to accept for the 3rd time.
Well, you're only looking at the last 2, what actually went to council, because apparently the 50 campground was amended to a 14. It's the 14 versus what's in front of you now. Those are what you look at. The original, the first of the 3, doesn't come into play. And the last one that was in front of the commission doesn't come into play. The 50 lot, it's the 14 lot, because that was what was ultimately disproved by the council, versus this 24. And you look, does it differ?
But the use is still the same. It's a campground. Nothing has changed with
That's
that.
the broad interpretation.
I mean, a campground is a campground.
And it sounds like what staff is urging is, it's not just the use as such. It doesn't have to be a marina versus a campground is a completely different use. But you look at it, in the definition of conditional use, it brings in everything, the intensity of the use, how the whole plot's going to be used.
But again, this whole plot was originally presented as a campground.
I understand that. I mean, I do not make this decision. I'm just telling you what you have to look at as part of this question.
And our decision, the way we looked at it, was after conversing with the county counselor's office. It is the intensity. That's the main issue that we're looking at. So it's, 50% is a number that we use for substantial improvements, substantial damage in the floodplain. On non-conformings, 50%. So that's kind of the number that we use for the barometer to look at this.
Mr. Chairman, might I suggest the man that wrote the letter that we've read, I think he's sitting in the audience here. We've heard their side of it.
No, you have to from the applicant first.
Yeah, I mean, I'm sure we will get to, I'm sure we will get to the council that wrote the.
I don't know that we have to, but go ahead. I won't debate.
Yeah, I mean, think we like to keep it in the regular format, but I am just as interested in this as everybody else here, that's for sure.
So when the issue is, are you going to proceed? It seems like it should be debated and finished before we would go on, but if you want to follow the procedure, go ahead.
I have a question of staff, okay? If this is approved as the map shows, okay, would this applicant be able to come back at a later date and ask for more campsites to the immediate west of the LaCrone property or immediate south next to the railroad tracks?
Well, number one, what is being proposed, or at least the recommendation, is on a set number of campsites. So if they wanted to change that, they would have to come back and request changes to the conditions, which we've had before with other conditional use applications. So that would come back to the Planning and Zoning Commission and then on to the county council.
So while this is being considered to be approved with buffers and the like, okay, and Mr. LaCrone has wrote a letter saying he has no problem because there's nothing behind his house.
Right.
There's nothing to prevent the applicant from coming in at a later date, apply for modification of conditional use permit and put more trailers or RVs behind Mr. LaCrone or along the railroad tracks.
It would have to be approved by the council to do that.
And Mr. LaCrone would be, we would notify.
Right.
Yeah.
Normal procedures. Okay.
Yes. Be like a brand-new ramp.
Well, it would be, it's a little different. We notify the adjacent property owners with that, where conditional use, we do 500 feet, so, but he would get a letter because he would be adjacent.
Any other questions of staff? Yeah, Mr. Leonard?
What happened with all the other problems we had with this site? Wasn't there several other issues, meaning condemned buildings that were supposed to be cleaned up, actually trailers on the site that didn't have a permit to be there?
That has all been rectified with the exception of the rack storage structure. So I'll explain that. Yeah, there were 2 buildings there that were condemned or substantially damaged, and those have both been removed. All the code violations that neighborhood preservation cited them with, those have all been taken care of. The site's been cleaned up. There was one trailer that didn't have a permit that has been removed from the site, so that's been taken care of. So the only thing that's left is the rack storage building, and that is on, of course, a separate piece of property from what this request is on. But that is going to take a structural engineer to either certify that it meets the building codes and structurally sound, or they're going to have to come up with some way that the building division can at least look at the piers and be sure that it meets codes before that can be approved. So we're not sure what's going to happen with that yet at this point in time, but that's the only thing that's left out there.
Yeah, so far as the record, the rack storage building is not part of this application.
Right, it's not part of this property. It's owned by one of the owners but that's applying, but it's not on this property that's being requested for the conditional use.
One more question for Bob. Probably a legal, since there's so many conditions on this, and as Ron mentioned, we've had this before us several times. One of the things that staff has on recommendations number 2, the county shall have the power to enter at reasonable times for the purpose of inspecting, investigating conditions relating to the enforcement of the conditional use permit. And there's quite a lot of things in here. Just curious, when, let's say one of these are in violation, what's the reasonable time? Is it spelled out? Does he have 1 or 2 years to rectify it? And does it cease and desist then, or is it just a fine, $100, and next time you do this, $200? Because it's not just, there's quite a lot of detailed, conditions on this, and there's a history of, with this property, so I'm just wondering how it would be handled from an enforcement standpoint with the county.
Well, it depends on what the violation is. For example, if you've got a structure that needs to be painted and it's the dead of winter, they'll give them until May or June to paint it. If it's a derelict vehicle, and it can be taken out of there fairly soon, they'll give them a week or 2 weeks to do it. Fines aren't imposed until it goes into municipal court, so they don't comply with the original order, to cease and desist, whatever, to paint. And If they go through that process, what the notices are sent out, there's re-inspections, it is not complied or in compliance, then tickets are issued, they go into municipal court, and they have to deal with the judge, and at that point, if it finds there's a violation, then a fine can be assessed for each day, and it's, but within the judge's discretion.
I think if I can address your question, I went down there Sunday and looked at it, and I had been down there many times over the years, and it was in non-compliance for many, many years with notices up, and nobody did anything about it. But now, at the third try, they made an effort and cleaned it up, and I will give them that. It is nicer than I've seen it before. But, so that's, but his idea is a little bit concerned about this long period of non-compliance, and now we're going to say, gee, we're going to come in and put another notice on it if you don't comply. And it seemed like those notices didn't do anything for years and years and years in the past, so.
That's what I was probably trying to express, I guess, since we don't have a...
Well, I mean, the problem I'm having answering your question is it's so general. You know, are we going to, can you really assume that because there's been problems in the past which have been rectified, that if an unspecified issue comes up, it will not be addressed timely, it will go to, I don't think you can assume that, no.
Well, this wasn't painting though, Bob, it was the 16 conditions that we have here specifically for those, because they're addressing this application specifically. So it isn't a general question I'm asking, I guess. I mean, these are pretty detailed conditions on this property.
But the items in the conditions aren't all as a result of non-compliance on the property owners. A number of the conditions were placed in as a way from our department to make the site so that it would be more acceptable to the adjoining property owners, I guess. I mean, I don't know that we always had active violations on the site. There was some time when we didn't have violations on, where they may have been in violation, but the county hadn't cited them. No one had complained to our office. It's not an area where we have active sweeps to look at things. To say that they knowingly were in violation for long periods of time, that's not necessarily true. But the other point I just wanted to make is every property owner in St. Charles County, when we are looking at violations on their properties, every property owner has the same due process as every other property owner. We can't hold some property owners to a different standard than other property owners. Everything has to be the same. And so when we saw violations were brought to our attention, then we pursued violations through our normal process. And it resulted in them getting the site cleaned up and in compliance.
I have a point of clarification I'd like to get from Bob and staff. Listening to all this, both at the P&Z meetings, at the council meetings, I kind of get an idea what everybody's looking for, in my opinion. Mr. Kajar is wanting some campsites to help his marina and the people that want to spend the night. I believe the LaCrone family, if you read the letter real closely, they're concerned that they have some buffering in some places where they don't look out their kitchen window and see campers. And I believe Darden Club is worried about the number of possible campsites could be that at a later date, okay? And they're worried about the campsites being right up close on the railroad tracks next to the property line. So my question to you folks is, hearing all that, is there a way you could put a condition on the approval of this, that the property behind LaCrone's residence to the west and to the south along the railroad tracks, the part that you see on the map that is not being developed in this, could be a dedicated green space with no future development on it that would give the people some elbow room where their kids could ride their bicycles and stuff like that, and maybe that might be something that the other parties would be accommodate?
Certainly the commission can add additional conditions. Rather than saying it has to be dedicated as green space, that would, that would be like a deed restriction and stuff, and that would be kind of out of our control, and someone else could buy the property and maybe not, that deed condition may not.
How would you suggest we craft that?
Yeah, but I mean, one way that I think is a good way for the Planning and Zoning Commission to ensure that this doesn't encroach further to the south is to say that I think the measurement is about 1,000 feet between the southern property line and the campgrounds. You could make a condition that setback be 1,000 feet, and I can measure it on the maps and give you a number. But you can make a condition that it be that. And if they choose to alter this condition, they have to come before the Planning and Zoning Commission with a new conditional use permit and a new public hearing. So then we could have it kick in so that everyone within 500 feet's notified, and, so it's not something that can just slide in under the radar. That's certainly a valid condition that you guys can put on there. Do you want me to take a moment and measure it, or while they're talking? Okay.
Any other questions? Yeah.
Let's
No,
continue.
this question
yeah.
to staff, we'll go ahead and hear from the applicant. The applicant would care to step forward? Can you raise your right hand for us? Do you swear to tell the truth, the whole truth, so help you God?
I do.
Okay, can you state your name and address for our record, please?
John Kajar, 2021 Highway C, St. Charles, Missouri, 63301.
Go ahead.
I was going to put a picture up. Is that okay?
Yeah.
Yes.
Yeah, just put it on that. Yeah. They'll go ahead and take it.
That's a picture from Darting's driveway looking at Two Branch Marina, and before the leaves are on the trees, so they really can't even see our property. And that's a creek that runs between our property as well as the railroad tracks. But we'll talk about that later. So I'm here to represent JOK and Two Branch Marina. And as you know, there has been a prior application that was denied. We started this back in July. And when we made the original application, we were not aware of any violations on the property. And there was no history of violations. We may have had two buildings there, since we bought the property, but until the county comes along one day and says, hey, it's condemned now, we didn't know it was in violation. So before we got to the first P&Z meeting on the last go-around, I had all these violations, and, Darting sending a lawyer, and all they want to talk about are violations at Two Branch and not the application. So that's kind of how that went. So, that was started in July, and that didn't finish. Those violations, I couldn't get through court until February this year. So there was no way I was coming back to this council with having anything on the record. And as far as the rack storage goes, I know the county is, their office is still concerned about it, and we have a plan to deal with that. But as far as the ticket goes, it was thrown out in court. So there's nobody can find that violation. There's no ticket that says the rack storage doesn't have a permit because the ticket is not there. Okay, so, and at that time, Larry LaCrone was in opposition. So, and Darting was in opposition. And all through the whole process, the lawyer tagged along. So it was hard to, to get through it. At the county council meeting in November, it missed by one vote. So you may ask me, what have I done since? So you know that we had all these violations, so in order to correct that, we got demo permits, and we got asbestos inspections, we tore down both buildings. If you read the LaCrone's letter from earlier, they didn't like our old dry storage, and there was some debris and some rubbish and things. I looked at all those letters, I looked at all the violations, and I didn't want anybody to say that I didn't work hard enough in trying to correct those problems, and that's what I did. Something else I did was I started the heavy shrub line. I went and bought trees, and it was a good faith effort to the LaCrones. I wanted to make sure they knew that I was going to do what I said. So I planted some trees, so hopefully there'll be some buffer between them and us for this season. I don't know if you got in your packets, but you should have a copy of two petitions and a letter and a letter from the O'Fallon Sewer showing that I contacted them, interested in having a contract for waste disposal. Well, you guys have the petitions. There's a petition that's short. And the petition that's short of names, and what I did there is I went to all the property owners that I could contact around me, because there's some houses down there that we don't own around the river side of our property. So I made sure I had all of them on board. They all signed my petition. I went to the landowners next door, John and Glenna Tolliver, and I showed them my plan, and they signed my petition. And at that time, I went to the Lacrones, and I asked them, to sign, and they weren't ready to sign at that time. But, he and I talked, and he really does not want the campers directly behind his property. And I gave him my word, and I said, I'm not going to do that. Then I showed him my plan for these 24, and he wrote a letter for this application, for it. He's not in opposition anymore. Because, he knows that I went to him before I tore everything down, or Two Branch tore everything down, and, I wanted him to know that when I told him I was going to do something, I'd do it. And that's what we did. Do you have a copy of Larry Lacrone's letter?
Yes.
Okay. Okay, another thing, so I was thinking to myself, what else could I do? I don't want the lawyer to come, you're going to have to hear from him in a second. So, Darting Realty is made up of 20 people, and the director of Darting Realty is Art Bond. He has got an architectural firm in Clayton. He used to have a boat in our harbor, and we actually bought our John boat from a couple years ago when he was getting out of boating. And I gave him a copy of our plan with the 14 lots, and I asked, I told him I'm looking for a friend. I want to make whatever concessions I can make. And he agreed that he'd go show the club. And then I met with him a couple weeks later, and of course, he said he showed it to him, and he was sorry to express that they were going to send a lawyer again. But he thought it would sail right through. I don't believe that he thought that it really was a bad idea, and I know that he told me that he talked to Adolphus, which is Adolphus Bush, who sold me the property, and he didn't think there was going to be any traffic issues, and they've been down there for a long, long time. So what else could I do? So I tried to contact Adolphus, and the only way I could do that is getting to his land manager, whose name is Gary Sigors, I think I pronounced that correctly, and I talked to him about a half hour about the project. I emailed him the drawing, and he said he'd get that to Bush. And they said, he told me he was going to. I don't know if he came tonight, but I don't think he did. But he told me he was going to send it to Bush. And when I talked to him after that, it was the same thing. He owns a little piece of property by the railroad tracks, and he's okay with it. And he thinks that Adolphus is okay with it. So, but there's an interesting relationship here between Adolphus and the Darting Realty people. Now, the group is only made up of 20 people, and they're all, wealthy, smart, and educated people. He could have easily sold them the property. Adolphus had to go out, and he had Jeff Schneider put up a sign. You mow the property, put it out for public sale. It was a financial burden on me to buy it, but this group, this Duck Club has only got 20 members. Could have easily bought the property. Nobody would never have known. But he didn't. They did not do that. So they would have easily been able to purchase it. So why are they spending so much effort prohibiting my use? They would have had the inside track on it. But instead they just keep sending a lawyer. It's kind of, I don't understand that relationship. That's why I put the picture up there. Because in the other meetings, they were talking about the railroad tracks and being close to their property, and I just want to show that they can't even see the property from their driveway. I agree with the staff recommendations, and I want to follow them. So I'm excited about doing this. I'm motivated. I'll do whatever you guys want me to do. What do you guys think?
Any questions for the applicant?
I have a question. Did you sign that contract with Fallon Sewer?
It's a
We got it
propo-
said a proposal, but did you sign it? You agreed to it. On the bottom, it says agreed to and accepted. And
I don't have anything for them to do. I can't have a contract with them.
what kind of septic system do you have now?
It's,
You got a tank?
it's an approved one. It's an approved one. They'd have to answer the question.
When's the last time you've had it pumped out? I'm just saying that.
I don't know
Well-
if that's, I don't know if that's a concern. O'Fallon Sewer, the only reason I went with O'Fallon Sewer is because the people next door, they have Johnny on the spots. They don't have bathrooms. So I know that they're down there and they have the equipment to deal with it. But the county asked me to put a holding tank on my site plan. So that's where that plays in. O'Fallon Sewer has the capability, they can put the tank in the ground and they can pump out with service. But the point of that is to show the intention to be as in full compliance as I possibly can. If I can't use the property this way, what's the point of owning it? Especially with such an opposition from such a wealthy group of people that could have easily bought it.
Is the sewage tank going to be underground or above ground? I thought it was supposed to be portable.
It could be above ground or below ground, whatever the county wants me to do.
Okay. I noticed
on the plan, it's
contract
above ground.
With O'Fallon Sewer Company, is there, that just said that they would pump it out for a certain amount, for a certain price, can you hold them to a time frame if there's water coming up for them to get in there and get that out of there? Or are they just going to say, well, we didn't get the phone call, or,
Well, I'm assuming that burden's on me, not them, and it's, I'm the one that would have to want to have, I would think that there'd be a check valve in that tank to where once it's full of water, and if water went over it, nothing would come out. That's the way I'd put it in. But if that were the case, it'd be the burden would be on me, and you'd have to think that, hey, this guy's going to want raw sewage floating around his property. And that's something I wouldn't want.
Well,
It's a recreation area, people to have fun there, not walk around in sewage.
Relative to this tank, if it's above ground or below ground, it's going to have to be constructed so that it's not going to float down the river in time of a flood. Like we require propane tanks to be secured, and things of that nature. So that's stuff that we'll look at through the site plan and the building plan review process, because this tank's got to meet all of the federal flood regulations and things. Yeah, there is no evacuation plan to pull out a sewage tank. It is to stay there and not be inundated with flood waters and not leave the property.
Okay.
Mr. Cronin?
Mr. Gajar, I'd like to thank you for cleaning all that up. I think you put a really good, hard effort into doing this, and I think you should be accommodated for that. But I have a question for you. I understand LaCrone's, their concerns, and I also think I understand Darden's, and I think I understand yours too. Do you have, what long-term plans do you have right directly behind the LaCrone's house in that little narrow strip to the left, and the bigger piece of property to the south along the tracks? Do you have any plans for that long-term?
No, I think that your idea of a green space is a good idea.
Okay.
But if you wrote it like that, I think it would offend LaCrone, because I am the majority landholder in that spot, and Jim Bethman and John Bethman farm that for us. They farm a lot of ground down there, and I think that the LaCrones would want us to keep farming it. So if we did something that wouldn't allow the farming of it, I think that would hurt them.
Okay, I have a lot of experience with conservation easements on ground that I own in the Mississippi River floodplain. Ducks Unlimited has one that you can actually keep farming on. You just cannot build and subdivide on. You get a great tax deduction for it, and I'm sure it's something that the members of Darden Club are aware of as well.
Okay.
And I'm thinking that might be something that would work for you. It would probably be a good financial move for you. The folks that I've done it with, I'd be happy to give you a name. I think it's something that the folks at Darden Club would be very interested in seeing. And I think LaCrone's, knowing that they wouldn't see anything back there but farm fields down the road, would probably be something that they would like. But if you don't have plans for that, might be something that would really sway my vote, because I understand those folks thinking that we got 24 now, we get 24 a few more years, we get another 24 later, and pretty soon those people are spilling out on their neighbors, okay?
Right.
And I would just like you to consider that and maybe talk to Darden and the LaCrones about that.
Well, I mean, that definitely seems like a good idea. And I think that would definitely, I think everybody, I have no problem with that. I mean, the main purpose of this, the marina's not full. People who want to camp on the weekends are going to hopefully have a boat. Those couple people I have down there, it's just that way. They have a boat or something they want to keep in the harbor.
Will those 24 last you for a lot of years, you think?
It would be a very good start. The whole idea is to generate more income, and we can clean up more and cut more grass. I mean, there's a lake back there. I'd like that to be like a park, but there's no, I have to go. I spend an awful lot of my personal time working on that property, and for not to make any money, what's the point? It's a sweat equity project. We've been working at it for 15 years. I got a huge investment in this other piece of property that I can't use. I get $800 from the Bethmans every year.
I have a question. The dialogue between Joe and Jan, what if we add a condition with that 1,000-foot setback? What would you feel about that?
I wouldn't do 1,000 foot.
The problem with the 1,000-foot setback is you can't tie the hands of future boards, and someone else could come in there at a later date and get approval to do whatever they want to do. I think the conservation easement would be something that would be probably much more acceptable to Darden. I've not talked to Darden at all about this, but knowing that those guys they're in the green space and the Ducks Unlimited programs, and Ducks Unlimited I put 80 acres in that program with Ducks Unlimited. It's a great program. You still retain the property. You can do a lot of things with it, but your goal of making it like a park, that's conducive to their program. And I think it would really protect the LaCrones down the road too, because they know that what they'd be looking at from years down the road is what they see.
Sure.
I live next to a county park, and I'm really pleased that it's a county park, because I know I'll be looking at a park for the rest of my days on this earth. And I think if that's compatible with what you want to do down there, I think it might be a good alternative. But the easement, the problem, I think that that can be changed. A conservation easement's permanent. But the tax write-off for you would be substantial. I mean, you get.
I'm definitely look into it.
I'd be happy to send you a contact with Ducks Unlimited.
Please do.
Okay.
That'd be great.
I thought you were saying when you were talking back with Joe, if doing a green space or something, that would put a deed restriction, whereas if we have a setback, we could add that condition. Whether it's 1,000 or whatever, fill in the blank.
Yeah, the measurement's like 900 feet would probably be a good number. You could condition it as a conservation easement. As staff, people have suggested conservation easements before, and one of the things that we were told was that the county does not want to be the beneficiary of the conservation easement. So the conservation easement needs to be set up to some, like Ducks Unlimited or something else, so that the county is not the responsible party for that conservation easement. That's not something that we do. So things that we do in county government is we put in setbacks. You can certainly make it that they do a conservation easement, but we can't, the county won't accept it.
Well, if we have a setback and they come back later to make that a conservation?
If we do a setback, they can make a conservation easement tomorrow. It's not anything that our local government gets into people's things. It's a private contract between the property owner and whoever they are granting the
easement.
easement
And as you explained it before, that wouldn't do any putting a setback in the condition isn't putting a deed restriction on some future owner of the property.
No, it's not. No, I mean, and you could do a deed restriction too, but I mean, I would think that through time and space there are ways to get around a deed restriction in the
Except,
world,
well, the conservation easements are locked down. I mean, the Nature Conservancy, a lot of different
Yeah.
organizations offer them, and they're very willing to work with you. Also, just speaking, because I like them, I think they're a great tool for succession. You would basically get an appraisal for that little piece of ground prior to doing that, and then after the conservation easement, and whatever the amount difference is, and usually it's 60-70% of the value of the property, you get a federal tax write-off of, that you can spread out over 3 years. I mean, for what it's worth.
They can't restrict like road access or anything on the property?
No, you negotiate that with them, but I found them to be very easy to deal with, okay? So, I mean, I don't know what your timetable is, but if that's something that the attorney from Darden Club thinks that Darden members might be interested in, then maybe if you want this table to work that out, I'm fine with making a motion of that, but that's up to the rest of the board, this board, whether they want to grant that or not.
Okay.
All right, any other questions for the applicant? All right.
I wanted to say one more thing.
Yeah.
The second page of that petition, I didn't get those signatures. A guy in my harbor, his name's Wayne Stewart, and he filled out a card. He filled that up in 2 days. He knows a bunch of people. I thought that was neat. Those are just people in St. Charles County. Those aren't people that came down to my harbor and signed. People heard about my plight and through Wayne and signed. So I thought that was pretty neat. I appreciate him doing that. So. Thank you very much.
Thank you. All right, we will now open this up to the public, so if there's anybody in the room that wishes to speak on this application, please feel free to come forward. Sir. Yeah, come on.
Good evening.
Can you raise your right hand for us?
Yes.
Do you swear to tell the truth, the whole truth, so help you God?
I do.
All right, can you state your name and address for our record?
Wayne Stewart, number 10 South Hillview, St. Peters, Missouri.
All right, go ahead.
And I just want to say, yes, I did circulate the petition. I think it's a good idea. I think it's revenue for the county. And my parents had a clubhouse down there years ago when it was Wheelie's Harbor. I'm sure you guys are all too young to remember that, but I think it's a good way for families to have recreation. And I just want to add, I did fill up that petition really fast. Nobody I talked to was against this campground. I just wanted to tell you that. I think I could have filled up a lot more petitions than that. It wouldn't have taken a lot more time. But they all thought it was a good idea, everybody I talked to. And that was from St. Peters, St. Charles, O'Fallon, people from all over. And I just wanted to let you know that. And I appreciate your time. Thank you.
Is that it?
That's it. Is there any questions for?
Fill out a card.
Yeah, just make sure you fill out, okay, you got it, all right. All right, is there anybody else in the room that wishes to speak on this? Yes, sir. Can you raise your right hand for us?
Sure.
Do you swear to tell the truth, the whole truth, so help you God?
I do.
Okay, can you state your name and address for a record?
Sure. My name is Terry Rollins. My address is 5128 Lakeview Drive, Granite City, Illinois.
All right, go ahead.
I just wanted to voice my support for the campground. We used to be at Johns Harbor. We moved over to Two Branch. It's a great place for families to get together. And everybody I've talked to has voiced their support for it as well. That was it.
Any questions? All right, thank you.
Okay, thanks.
All right, continuing on, is there anybody else in the room that wishes to speak on this application? Can you raise your right hand for us? Do you swear to tell the truth, the whole truth, so help you God?
I do.
Okay, can you state your name and address for a record?
Sure. It's Elizabeth LaCrone at 1949 Highway C, St. Charles, I guess, Missouri. I will give total kudos to him. He has cleaned up the area. He has put the trees down, everything that he was said that he would do. We don't have a problem with him putting them by the river. Our biggest problem is that we don't want them right up on our property line. Of course, like you said, we don't want them behind us, by any means. We don't want them out to the side of us. We moved out to the country to be away from people, not to have people on top of us. I do have a couple little things, though. I just was wondering if he's going to expand out. I know right now you're only at 24, but when he does expand out, where is he going to go with that expansion? That's one of my questions. And the other thing is, Jan said that they don't do active sweeps down through that area, so how are they going to keep track of that they're staying up with their conditions if you don't do sweeps through there? Other than that, like I said, I will give him everything that he's done what he said he was going to do by cleaning up, the area and, again, planting the trees, and we greatly appreciate that. That's all I have. Any questions?
Well, I think we can probably answer at least one of those questions, is that...
The sweeps, we can certainly make it part, when we have a new campground like this, we can make it part of it. Also, if you see something that's out of whack, you can always call our office. But yeah, if the conditional use permit is approved, if the way the conditions are structured, I would think the Neighborhood Preservation Division would put it on a regular timetable that they would visit the site.
Okay.
Yep.
Any questions? All right.
All right, thank you.
Is there anybody else in the room that wishes to speak on this?
I guess I'm the elephant in the room.
Well, Mr. Elephant, can you raise your right hand for us? Do you swear to tell the truth, the whole truth, so help you God?
I do.
All right. Can you state your name and address for a record?
Yes, Drew Weber with Hazelwood and Weber at 200 North 3rd Street in St. Charles. And as you know, I represent Darden Realty Company, and they do oppose the application in its previous iterations. We opposed it and still do. And I think Mr. Setley hit on a perfect point earlier that now is just not an appropriate time because the county council denied the application for 14 campsites in November. And as we know, the UDO states that if an application is denied, it cannot be resubmitted to the Planning and Zoning Commission for a period of at least 12 months from the date of that decision, except in cases where the use requested in the new application differs from that presented in the original application. Now, use is not defined in the UDO, and I know that the county councilor's office has said, well, but normally we use these 50% provisions throughout the code to determine if there's a substantial change. They may normally do that, but that's not in the code as far as conditional use permits are concerned. And there's a distinction in zoning law in general between area restrictions and use restrictions. And an area is like the number of buildings on a site, or setbacks or height. Those are area restrictions. And then things like non-conforming uses and variance, they're subjected to different standards than maybe use variances or the actual use of non-conforming use. And so we're talking about two different things. The number of campsites, that doesn't change the use. And in fact, that was recognized by the county originally because, as you know, the original application was for 50 campsites. It was amended in the middle of the process down to 14, but yet it wasn't resubmitted. It was deemed, it's the same use, even though there's a different number. So I don't know why the analysis would be different now. It's still the same use, and under the UDO, it shouldn't be considered until at earliest November, 26, 2013. And the second thing is that the county council, as you know, issues findings of facts and conclusions of law after their decisions. And the county council denied the conditional use permit and said there were two reasons. The first was that basically granting the permit would result in heavier RV traffic. There's only one road in and out of this area, it's Highway C. And especially during a flood, an emergency like a flood, the county council found that 14 RVs would be a substantial traffic hazard. Well, now we're at 24, so the problem isn't getting better, the problem's worse, and I don't know why the county council's findings of fact should be different or shouldn't be followed. And the second reason was that the applicant failed to restrict occupancy or impose a plan for orderly evacuation. Well, this week, you and I received their evacuation plan, which is certainly a good first step, although there's no I mean, it's not much of a plan. It doesn't provide for routes of evacuation or procedures for preparing for evacuation. It doesn't say how people will be notified that there is, in fact, an emergency. We know the marina posts river stage levels, and after a certain point, I think they said it's 428, Two Branch will recommend that all leaseholders, which I'm assuming means campers, that all leaseholders will move to higher ground. But they recommend that they won't, there's no indication that the campers will actually be notified. And then lastly, it does not state where the higher ground is or how to get there. I mean, there is only one way in and out, but the people at the campsite might not necessarily know that. So then, some of the things that were brought up, I think I want to bring us back to what a conditional use is. And a conditional use is obviously not a permitted use. Something is called a conditional use because there's a recognition that it may not be appropriate in that specific zoning district. It may be appropriate in certain instances, but it may not. So this, because the county has already found this use is not appropriate, I don't see how the county can turn around and find that it is appropriate. It's the same use and nothing's changed. So in short, again, first of all, we don't think that this application is properly before the Planning and Zoning Commission because it's been less than a year. And then second, even if it were properly before the commission, it's still the same use. The findings of fact of the county council in denying the prior use, they're still applicable and nothing's changed. And then if you have any questions, I can certainly answer them. And Mr. Cronin, you probably have questions about Darden Realty's approach to these conservation easements. I don't know. I'll just have to tell you, I can talk to them.
I know Mr. Bush has done them. I've done them. Okay, and I know there's a lot of duck clubs that are doing them. They're a good thing. Okay, and at this point in time, I know these folks want to get moving, but I tell you, I was on the Mississippi in Lincoln and Pike County today, and by probably tomorrow morning, most of this is going to be underwater. Unfortunately, there's a lot of water moving down. So I like to make a motion that we table this, and I would like Mr. Kajar to have some time, and I'll be happy to connect him with the folks that I know, and I'd like you to connect with your members. And I think the Lacrones would probably like to see that happen too. And I think that you folks are you're getting closer, okay? And maybe we can work this out where everybody's happy, and that's a good, perfect world if we can do that. But I mean, if you're good for a month, okay, and these folks will work with a month. And I can tell you the ins and outs of that and get you set up with folks. I mean, either that or we vote on it tonight, but I'd like to make a formal motion that we table this and let you folks have a meaningful discussion on it.
Well,
I would go for that, if we're back to the point.
okay. Well, yeah, we'll finish up the discussion here, and I think when we get to the...
I have a question for Mr. Weber.
Yeah.
Looking at the findings of the county council that you referred to on page 3, where your statements, 3 reasons why this should be denied. And my question is, has Dardenne Realty done anything to abate the safety hazards that they're causing? You say Dardenne Realty allows bow and deer hunting on its own property, creating another safety hazard. So have they taken care of their problem?
The safety hazard that would be created that's referenced there would be a concern that if you have a lot of people at campgrounds, specifically in prior iterations, but even in this current iteration, if you have a lot of people that don't know the boundaries of the property and they go exploring, because frankly, when you're camping, something you do is walk around and go exploring. And this is a country area, as Ms. Lacrone said, that if people go exploring onto the duck club, that is a safety issue. And it's not a safety issue of the duck clubs, of the way they're currently operating. It's a safety issue that would be brought about as a result of a campground.
So you're telling me the duck club hasn't posted their property lines to advise people that there's bow and deer hunting on this property?
There might, I'm not sure, but I think we also know that not everyone listens to signs, and signs aren't always in a perfect view. And as you saw from that picture, it's a hilly area. there's woods, so you just might not know it.
Any other questions of Mr. Weber? All right, thank you. All right, is there anybody else in the room that wishes? Yes, sir. All right, can you raise your right hand for us? Do you swear to tell the truth, the whole truth, so help you God?
Yes, I do.
Okay, can you state your name and address for a record?
Jerry Doherty, St. Charles County, Portage de Sioux, 1320 Church Street.
Go ahead.
I was on the county council, and I worked for about 3 or 4 months on this project and put a lot of work into this, and most of the restrictions that are in that were because of myself and Wayne Anthony and Harold Ellis. And I will tell you, for the most part, that's a lot of code books, and they can go right down the river to the 2 campgrounds to the east of there if they want to do the sweeps and enforcement that you're saying they don't do. As far as the hills and everything that he's talking about, a railroad track over there, if we want to get that nitpicking on this thing and everything, I think we need permits for duck blinds, because them are man-made structures in a floodplain. How far do you guys want to go with this? I think Kajars have done everything they can out there to clean this place up. I went out there weekly with Rocky and everything, making sure this was all done. Problems we ran into there with legal and everything else is we couldn't stop this campground because of 2 Branch Marina, because it was 2 separate parcels. We tried to work all that out, and I think we've got that far. Mr. Cronin and myself, we've had several discussions over this over time. The property owners immediately adjoining this, Glenna Tulliver and everything, spoke with her last night and today. She has no problem with this at all, as long as the roadway access into there doesn't change. Larry Leckrone, I've had several meetings with him and talked with him and everything. As long as there's a restriction that there's not campers in the field behind his house, he's good with that. I don't think we really need Ducks Unlimited conservation easements and all that and everything. That's the way the duck clubs play the game. They like that. But you should not force the marina industry into this same game plan. Believe it or not, the marina industry in St. Charles County contributes half the amount to our economy that agriculture does. That's hard to believe, but we did a lot of checking into that when I was on the council. At that time, before commodity prices changed, in the 2007 EDC study and Finance Department, and in 2010 EDC backed it up. Basically, it was $46 million a year that ag contributed to St. Charles County economy. The marine industry contributed between 22 and 26 million. This is a viable industry. We need to keep it going. Anybody got any questions? Thank you.
Thank you. All right. Anybody else in the room that wishes to speak on this? Yes, sir. Can you raise your right hand for us? Do you swear to tell the truth, the whole truth, so help you God?
I do.
Okay. Can you state your name and address for a record?
John Berryman, 929 Ridge Road, Troy, Missouri.
Go ahead.
It's the first time for this. First time for one of these meetings. I left Lincoln County a long time ago because there was no zoning, and I lost quite a bit. When I come back from Europe, I come back and had a sawmill next door to my house, and during all these years since then, that was 39 years ago, I've never been citizen enough to come to anything like this. I'm quite impressed with what you guys did here tonight. And the only thing I have to say is that I bought a boat 6 months ago. It was in this marina over here that we're talking about. And I like the boat, but I primarily bought that boat because I was impressed with the people that ran that marina. I mean, I've been a contractor for 38 years. I retired last year. And I was impressed with these people. I mean, they do some things that most people couldn't even begin to do. I mean, he built that marina, the things, the structure. I went back to Texas for 2 or 3 months, left my boat there, and my brother watched it a little bit. When I come back, all those things he talked to me about what he was going to do before I left. When I got back, they were done. That big building was down and cleaned up, and the whole everything that he discussed that he had to do in order to do what you guys need to do, he did it. This man, if I was going to have someone in my county paying taxes and building a business, this is one of the men I'd want to be there. I mean, I've dealt with a lot of people in 38 years. I mean, in the construction business, this man impresses me as he's one that when he says he's going to do something, he does it. You won't find that every day, this day and time. Thank you.
Is there anybody else in the room that wishes to speak on this application? There's no one else, then we'll...
You have a motion to table.
Yeah. Bring it back before the commission. And there's no discussion. I mean,
Mr. Chair,
we have a...
Mr. Chair, do we
Yeah.
want to allow rebuttal? No time for rebuttal.
Oh, from the applicant?
Yes.
Yeah.
Does he has anything to say?
You don't need to talk.
Yeah.
You don't have to. I mean, just if you want the opportunity.
With respect to what the lawyer was saying, I mean, you can tell he's not saying much of anything, you know? I mean, what did he say? There's no reasons. Let me show you some pictures. I got more than that one I had. You know, they got a gate. You know, that's another picture. So, I mean, those wandering people are going to have to wander over the railroad tracks, cross a creek, jump their gate, you know, to get shot by them. So if they shoot somebody on my property, that's a kind of a legal issue for them, not me. You know, they can't. I mean, they can't. They're saying they're going to shoot somebody on my property. You know, that's an issue. It shouldn't be an issue against this application. In the letter that they sent to you, there's a, and I submitted, it's in the facts and findings. And it has to do with the county council, what he copied and pasted and sent in the letter to you. That's all they did. There's a paragraph in there that it's a block paragraph from the UDO, and the only, you know, I know he copied and pasted it from the fact findings from St. Charles County, but St. Charles County explained it a little bit better. In his letter, he should have put the first sentence in there. You know, the first sentence says, before authorizing the issuance of a conditional use permit, the county council may impose such conditions in will, in the county council's judgment. You know, so he just, you know, it just looks like they didn't, they disapproved it because of this reason, but they didn't put the whole paragraph in there. I don't understand that. You know, it was only one sentence. Why'd they take that sentence out? That sentence makes the paragraph make sense. So, and that's part of his 10-page dissertation as to why this is not a good idea. So, I just wanted to point that out. Do you want to see more pictures of the property? I'll show you a picture of their property and joined to our property, and the field we're talking about. If you back up a little bit more, you know, the field that we're talking about keeping the campers out, and I want to do that because I told LaCrone I was going to do that. You know, I don't think giving my property away is the way to do it, but I definitely would have no problem with putting some kind of restriction in there. But that field is over the railroad tracks, you know, and all the brush on the left side of the picture is their property. You know, so, I mean, they have to, and that's a hill on both sides. You know, so there's some distance there and some natural barriers already. You know, this is a picture of closer up of the field that shows the, you know, what's behind LaCrone's house. But normally that'd be planted in corn. You know, so that would also be, you know, it's going to be a visual barrier between the LaCrones and us and the Duck Club. You know, and also the other thing I want to point out is the hunting season is not in sync with the camping season. You know, so that argument also doesn't make sense to me. You know, they're usually hunting, you know, in winter, and we're camping in spring and fall. If you guys want pictures of copies of these, I'll give them to you. Or you can. You guys got any more questions?
The only thing that Elizabeth brought up, because I'm not so much concerned about the hunting property, but their house obviously joins your house, and she mentioned two things. One, the active sweep, and second, the expansion, which would be down towards the lower part of the screen.
Do you mind if I put my picture up there? Because that just shows the outline, and
Sure.
my diagram shows. So the LaCrone's property, that's the outline of their field, and they own enough ground to be in compliance with the county. But their house, is like over here, roughly. I mean, I don't know exactly, but it's closer to the road and more to the center of the property. And that's what I was talking about before. They're going to want that farmed. So, and that's what I told Larry. This field here, which is the picture I showed you, in the parcel that he farms, are in that ground. And that's, and I'm okay. I told Larry I wasn't going to put them behind his house, and that's what I'm going to do.
That's what I was just addressing, because of one of her concerns.
Well, that's what my intention is to do. If we want to say we won't put campsites in this field, that's fine. I have no problem with that. But I don't want to, if it's such a distance that I don't have my dimension lines on this, but, it's 1,100 feet to Two Branches property line from the railroad tracks. So, I mean, if you can imagine, if you see that other picture where it shows the lake and things, I would like to be able to use that lake eventually. So I don't want to have the setback so far in that dimension. To the railroad track dimension is fine, but to the other way, the lake is a good use for the property down there too. It'd be, there could be fishing there, people sit in a lawn chair around the lake. I don't want to wreck the use on that for the Two Branches property on that,
If I could interject, if they came in for an application on either of these two properties, that would require a full new conditional use permit hearing and everything just like today. They could not get that with an amendment to this existing conditional use permit because it's on a different piece of property that's never been advertised for public hearing for this use or been approved. So that property wouldn't be tied into any setbacks or anything. It would be something that whatever commission is in force at that time would discuss, and at that time the LaCrones would have an opportunity to speak in favor or opposition to that request. We really need to stick with the property that we have and the 24 campers that we have before us now, and things that you want to condition to ensure that on this property that was advertised.
And then the other thing I'd like to point out on this plan is that they're saying there's no way out, but one way out, and then there's a driveway there, a second access to this property, and it's right here. That's there. This is there. That's been there for years, onto Highway C. So, I mean, and that ties into with this evacuation plan. If you were to ask him to write you an evacuation plan, if there's any of the things he said to you that weren't in my plan, he wouldn't put them in there either. I can't write something that's going to make me liable for everybody's property. But I can definitely use my time and my equipment to help people get their things out. I can't tell them to take this route only, I mean, but I'll do whatever we can. And we're going to alert them. And so we did today. We know the flood stage is coming up to 4:35, and at 4:28, it's definitely going to go past that. And we called everybody, and they're gone already. As simple as that. So. And there's many more across the street, there's only one driveway on their property that, for the campers to get out, and they never have any problems. There's no massive accidents or people running into each other because the water's coming up and they can't get their trailers out and they're running into each other. So, I mean, that's been there for years, and there's only one road in and out that I know of to that. And there's many more campers than I'm talking about here. So, I mean, so those issues, those are non-issues. It's just a mouthpiece for some people that don't want to show up in person. And that's what he's done to me every time.
Any other questions? All right. Thank you. I will now entertain any motions on this particular
have the motion.
application.
You have the motion to table.
Is that-
Yes, I'd like the motion to table.
All right. Is there a second?
I would second.
Okay, Mr. Settley. All right, Mr. Settley, how do you vote to table the application until next month?
To table the application.
Okay. Mr. Cronin?
I vote to table.
I vote to table as well. Mr. Ellis?
No.
Mr. Fromm?
Abstain.
Mr. Griffin?
No.
Mrs. Keckner?
No.
Mr. Kuhn?
Table.
Mr. Leonard?
Table.
Ms. Polly?
No.
All right. The motion to table passes, let's see, 5 to 3 to 2. Right,
5 to 3 to 1.
5-4-1, excuse me.
5-4-1.
Yeah, 5-4-1. Five in favor of tabling, 4 no, and 1 abstention. All right. We need an absolute majority?
Right.
Okay. Thank you for bringing that up. So, the motion to table fails. So we need to bring this back and vote this up one way or down, up or down, right? If we don't table it, we gotta.
Well, yeah, I mean, essentially, unless something changes, then you want to talk about conditions, I mean, there's other ways you can do
Right.
this.
So could we go over the point again? We heard a legal analysis over usage and whether it was appropriate for us to hear this matter. And I think
Right.
the analysis that Mr. Young presented was compelling to me. This was an application for 50 campsites, then turned into 14, that turned into now 24. It's the same idea, the same use, which that's what the ordinance, UDO is talking about, the use. It was the use before, during, and after this whole process of the thing. And I think they've got a wonderful idea, and I appreciate them cleaning up. But I think their hands are tied. We can't hear these things over and over and over and over with a slightly different use and say, now I've got 26 campsites instead of 24. I mean, we've gone 50, 14 to 24, and that's the same use. And the ordinance is clear that they got to wait a year. So that's my argument on that.
I think the
compelling-
I think the issue, yeah, I mean, and I've been wrestling with that issue myself this entire evening, because the down from 50 from 50 to 14, well, that change was made in my mind. That change was made before that hit any governing body, you know, and the UDO says if the governing body votes it down, so the governing body voted down the 14, and so the question before us is the 14 to the 24, how substantial a change is that, and does that substantially change the use? And that's kind of, you know.
And the use was a campground, and the use is a
Right.
campground, and you know.
But the question also before us, I think, do we vote the way we would normally vote and let the lawyers deal with the aftermath? But, I mean, that's up for each of us to decide, I think.
So Ron, is that the only reason you're opposed to it, though? Because it's...
Well, if it can be conditioned, I do think that the Lacrones, I remember their testimony and what this would do to their house, and how much he said he spent $200,000 on the house. And I've been down there many times, and I've seen it, and it was a mess before. And some of this stuff I don't want to get in a long debate about, but there was signs up, and the place pretty obvious. And I saw raw sewage and stuff like that. But there has been some improvement, so they took a step in the right direction. My gut is it should wait till November, or, you know, we could be hearing these things over and over and over. I think that the UDO has wisdom in it that these things, every legal dispute and controversy has to end at some point in time. That's why, you know, the constitutional principle, double jeopardy and retrying the same set of facts, it has to end some way. Stare decisis, if I remember my business.
Mr. Chair?
Yes.
To make a comment. I tend to agree with you, Matt. I think this issue with the UDO, and I think it's a legal issue. and the timing to me is one thing, but I think what I'm more impressed with is what's happened with the property, the turn of sentiment in the neighboring, or the neighbors in the area. The last time we heard that there was a lot of opposition to this project. I'm not hearing that at all, except from Darden. It sounds like everybody's in support of it. Yeah, I guess he could wait till November, and we'll hear it again, and then, you know, it'll pass at that time. But this sounds like a good project for the area. It sounds like they've taken great strides to deal with the problems that were down there, correct them, and I'm in favor of it. Thank you.
Any other discussion? I know there was some discussion about a possible other condition, so as we move forward, keep in mind that we may, if you want to add another condition on that, please make that part of the motion. But if there's no other discussion, I will entertain a motion to approve this application.
So moved.
Okay, Mr. Ellis has...
Second.
Second by Mr. Griffin. Mr. Griffin, how do you vote?
Again, I don't know, that just something to help that one property, and I don't know how to do it legally, as a condition, so they're not looking at other RVs and that little plot down the road. Is there a way of doing that?
The motion to approve has been made, and like I said, it was not made in that motion, so right now we're voting on the motion has to stand with the recommendations.
Can we add a condition later or not? No.
Or you want to withdraw?
Withdraw your second.
The motion and,
Withdraw your second.
And
I'll
discuss
withdraw
the
my
setback?
second.
I withdraw my motion.
Okay. The original motion has been withdrawn, and I will now entertain another motion with any other recommendations that...
Jan, what was the setback that you recommended?
You can see the measurements up there. Sorry, my mouse is not working. This line is 972 feet, and this line is 913 feet. If you did a setback of 900 feet, you could do that, or 950, because they have a road in. Sorry, is this making sense? I'm sorry, this is the northern part of line of the LaCrone property. The campers would be in this area and on this property. So that's the northern line. This is the LaCrone's property. If it would help, I'll throw the aerial underneath it. I don't know if that makes it clearer or less clear.
Okay.
So you could say 910 feet as a setback, and you could also put on that they do a conservation easement and that they have that in place prior to site plan approval.
I think, Mr. Cronin.
Can you pull up the aerial photo of where it shows the property lines? Okay. This is something that just came, I thought, real quickly. If you look at the sharp corner on the north side of LaCrone's property, okay, right there. If you went immediately to the left, okay, no, straight across, perpendicular to that round, right there. If you did a conservation easement for everything to the south of that, it would protect the Crone's house, which is actually on the north side of their property. It would give Mr. Kajar some room to add some lots later on, and the conservation easement would allow farming, would allow ingress, egress, would allow his lake that he's concerned. I can tell you, if that happens, I think that protects that lady's rights, not only now, but for years and years to come. I think Darden Club would be foolish not to take that, because that preserves that for green space. I think Kajars have room to grow their campground some down the road and get a nice tax deduction for preserving green space, and I will vote for that here tonight, and I'll vote for that in the council. If it works for you down the road, you can. If it doesn't work for you, you can always reapply down the road for something different. That's just a suggestion. And I don't know how you would word that, okay? That's going to take a little time, and that's why I thought it would be best to table. But if we're going to try to do it tonight, good job for Bob tonight.
Well, again, my same concern, just the language would, when Roger made it and then we withdrew it, just to help her concerns out. And she's really the in my mind, my biggest concern. So that she feels comfortable leaving this meeting. And again, I think the project is good, just like Sandy said, everything and the work you've done, commendable, everything's been positive, but just so that you can sleep well at night.
Jan, if we have a 910-foot setback, then what would be allowable in the property that's left behind the Lacrones and then the larger piece? What would be permitted in that area?
Every use in the agricultural zone, every use in the agricultural zoning district, so farming, and they're in compliance with the floodplain regs. I mean, I guess in theory, they could probably construct a residence on it.
If we just,
Use, but the agricultural district's pretty limited, and
if we just conditioned it with the 910-foot setback, the applicant could pursue a conservation easement
on his
own.
Certainly.
I mean, it's totally, we don't have to, like, we could just set up the setback to protect the Lacrones, and then
You want to set up a setback for just the use under the conditional use permit. Okay, it sounds like what you're saying. You don't want to have a complete absence of any use in the setback area.
Right.
You just do not want the conditional use. Right, you just do not want the conditional use to be allowed in the setback area.
to bleed down into that area.
Right.
Yeah.
Right. So I would make a motion however you word it, as another condition. You word it. And Bob likes the wording. And Roger likes the wording.
maybe we should have Jerry.
Yeah.
What do you want to, here, let me, you ready, Scrivener? The conditional use will be prohibited in the setback area, which is defined as starting in a line from the northwestern property corner of the Lecken Road property, directly west to the western boundary of the, what is this, the JOK's LLC parcel, and everything south of there.
To the next property line.
Well, yeah, I mean, that comes in southerly all the way of that line, and of the Lecken Road property, and to the west of the Lecken Road. I mean, you can further define it, but that's, I think it's understood what you want.
Well, based on that, I would make a motion
All right.
to approve.
Excuse me just a second. Now, that is for a setback. You could also say that you want that subject to a conservation easement. That would have to be presented at some point, but I don't, yeah, just take that into account when you're making the motion, because to clarify what we're talking about.
I'll make the motion with the condition that you had just given, Jan.
Second.
Okay, the setback.
All right, Mr. Ellis, how do you vote?
Yes.
Mr. Fromm?
Abstain.
Mr. Griffin?
Yes.
Mrs. Keckner?
Yes.
Mr. Kuhn?
Yes.
Mr. Leonard?
Yes.
Ms. Polly?
Yes.
Mr. Settley?
Abstain.
Mr. Cronin?
No.
I vote yes. The motion passes 7-1 with 2 abstentions. All right. The next item on our agenda is the approval of the minutes from the March 20th meeting.
I'll make a motion.
There's a motion to approve as recorded. Is there a second?
Second.
All in favor, sign aye. Aye. All right. Any other business before the commission?
Motion to
Seeing
adjourn?
none, there's a motion to adjourn by Mr. Ellis. Is there a second?
So moved.
All in favor, sign aye. Aye.